last night on his speech, the Petersburg Address, last night, Donald Trump bragged about how he got all this stuff cut from USAID and how he won't have to, spend all that money. Even though I've said here on Liberal Dan Radio, Talk from the Left, that's right, that if Biden was required by the courts to spend the money that, Congress allocated to be spent in a particular way, and if Biden didn't have the option to say, well, I'm just not going to spend it, then guess what? Trump doesn't have that authority either. And I've been saying that, and Republicans and MAGA folks have been fighting back over and over and over again. But it just so happened this morning that the Supreme Court swatted him down, shockingly enough. And I was listening to the radio this morning as I was bringing my wife to her physical therapy, and and the radio show host, Jeff, the guy I listen to, he was saying about how this ruling passed, but at the time, I guess they only heard the ruling and not the dissent. So it was an unsigned ruling that was 5-4. And most unsigned or per curiam cases, we don't know who the people are who voted for and against. But this example, this per curia case, had dissents. And the 4 conservatives who dissented put their names to it. So we all know who was part of the majority because the minority told us who they were. There's maybe one notable exception in recent memory, and that was Bush v. Gore. That was a per curia case that had a whole bunch of dissents as well. However, when I heard it this morning, Jeff, the host, didn't say who it was and didn't know who it was, but I predicted that it would have been the 3 liberal justices plus Justice Roberts, and I thought the 5th may very well have been Amy Coney Barrett. And I was right. That's who it turned out to be. So, again, one of the things I think that I do maybe better than some of the other hosts that are out there is I think for a layperson, as someone who's not an attorney, we will sometimes go over the rulings and kind of scroll through them and read what they have to say and give our opinions on the matter. So that being said, we do have the text of the ruling right here, and we will switch over to it right now. Supreme Court of the United States, Department of State et al. Versus AIDS Vaccine Advocacy Coalition on application to vacate the order issued by the United States District Court for the District of Columbia. On February 13th, the U.S. District Court of District of Columbia entered a temporary restraining order enjoining the government from enforcing directives pausing disbursements of foreign development assistance funds. The present application does not challenge the government's obligation to follow that order. On February 25th, the District Court ordered government to issue payments for a portion of the paused disbursements, those owed for work already completed before the issuance of the district's court's temporary restraining order by 11:59 on February 26, several hours before the deadline. Government filed this application to vacate the district court's February 25th order and requested an immediate administrative stay. The Chief Justice entered an administrative stay shortly before the 11:59 deadline and subsequently referred the application to the court. The application is denied. Given that the deadline in the challenged order has now passed and in light of the ongoing preliminary injunction proceedings, the district should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. The order heretofore entered by the Chief Justice is vacated. Now, of course, that doesn't necessarily go into the merits of the case. It basically just says the court now needs to explain why or what the requirements should be on the government. The Supreme Court didn't add any additional things. Now, normally that would be a pretty boring ruling to go over. And I haven't gone through any of this. But normally, such a short ruling would be a boring thing that it probably wouldn't even cover just to say, except for just to say, hey, Donald Trump got smacked down by the Supreme Court. He tried to do something and he failed because the courts told him no. However, this has a dissent. And it's Justice Alito, the dumbest Supreme Court justice in American history, in my opinion, is the one who dissented. And Justices Thomas, Gorsuch, and Kavanaugh joined, dissenting from the denial of the application to vacate the order. So that tells, if those are the 4 that dissent, we know who the 5 are. Does a single district court judge who lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to the question should be an emphatic no, but a majority of this court thinks otherwise. I am stunned. Well, you're stunned, Justice Alito, because you're a freaking moron, and if you look at my review of his previous authored rulings, you understand why Justice Alito is a moron. But yes, a single district court judge absolutely should be able to put a stay and put a stop to the federal government from doing things that the federal government lacks the authority to do, because that's how our court system works. Our court system works. You bring something to a lower court, to a district court. The district court makes its ruling based on existing precedent and current law. And then if there's a problem with that ruling by one of the parties, they appeal that ruling to an appeals court. And then if they have a problem with that, you appeal that ruling to the, Supreme Court. That's how our court system works, Justice Alito. That's how it works. In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department. They brought suit and claimed the current administration's temporary pause is unlawful. I mean, if presidents lack the authority, like Joe Biden lacked the authority to not spend funds that were allocated by Congress, then neither does Trump. February 13th, the district court issued a temporary restraining order requiring government to halt its funding pause. So, halt the funding pause, that's kind of like a double negative. It based that decision on finding that respondents are likely to succeed in showing that the government violated the Administrative Procedure Act. After issuing a TRO, the district judge grew frustrated with the pace at which the funds were being dispersed, and on February 25th issued a second order requiring the government to pay out approximately $2 billion. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order, and he took two steps that, unless corrected, would prevent any other higher court from reviewing and possibly stopping the payments. First, he labeled the order as non-appealable TRO, and second, he demanded that the money be paid within 36 hours. This left the government little time to obtain some review of what was regarded as a lawless order. The government moved for a stay pending appeal in district court, but the judge shrugged off the government's sovereign immunity argument and ignored the government's representation that most of the money in question, once dispersed, could probably not be recovered. Well, I mean, why would it be recovered if it's money that's required to be spent by Congress? Government quickly filed an appeal in the United States Court of Appeals of District of Columbia, but with only 4 hours to spare before the payment deadline, the D.C. Circuit dismissed the government's appeal because it took the district court's TRO label at face value. With nowhere else to turn, the deadline fast approaching, government asked the court to intervene. At the last moment, Chief Justice issued an administrative stay. Unfortunately, a majority has now undone that stay. As a result, the government must apparently pay $2 billion post-haste, not because the law requires it. I mean, because the law requires it. I don't know why Alito thinks the law doesn't require it, and it should be a requirement of Alito to actually explain why the law wouldn't require it, but simply because a district judge so ordered. As the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused, which you've done over and over and over again, Sam Alito. You've abused the power of the court greatly by overlooking, stare decisis, by, your Dobbs v. Jackson ruling, Burrell versus Hobby Lobby, Lilly Ledbetter versus Goodyear Tire, all these cases where you were the author of these cases, you failed your responsibility to actually act like a good jurist. Time does not allow a lengthy discussion of legal issues presented by this case. Of course it doesn't, because that's your excuse, because you would make a terrible argument if you decided to actually make such an argument. Brief summary suffices to show the district court's order should be vacated, blah, blah, blah. To start, it is clear that the district court's enforcement should be construed as an appealable preliminary injunction, not a mere TRO. A TRO, by its name, is temporary, and its proper role is to restrain challenged conduct, blah, blah, blah. The order here, which commanded the payment of a vast sum, in all likelihood can never be fully recovered, is in no sense temporary. But, I mean, there's additional spending that's to come in the days, weeks, months, years to come. So that's why it's temporary, because this is temporary spending of a much larger spending package. It's ignored that the order merely restrained government's challenged action, blah, blah, blah. Given its irreversibility, the district court's enforcement order effectively gave respondents a portion of the ultimate relief they seek. For these reasons, the Court of Appeals had jurisdiction to consider the government's appeal, and we have jurisdiction to review and summarily vacate that court's erroneous judgment. But there's still more spending to come that's going to be argued. So again, I don't know why Alito doesn't understand this. So even if the majority is unwilling to vacate the district court's order, it should at least stay the district court's enforcement until government is able to petition for a writ of certiorari. In considering whether to issue such a stay, we ask at minimum whether the moving party is likely to prevail on the merits. They already said that the party was likely to prevail on the merits, and whether that moving party is likely to suffer irreparable harm. What irreparable harm is done by spending the money that you're required to spend? If you're required to spend the money by an act of Congress, Congress says, here's the money, we're appropriating the money to here, spend this money as it's determined that the money should be spent at, it's not harmful to then spend that money. The harm is by not spending the money, especially when people need it. There's a legal idea, a legal principle of detrimental reliance, where I might make decisions based off certain ideas. And if, certain promises, so if somebody promises me, let's say a new job, let's say I'm extended a new job, I make a move from Louisiana to, let's say, California. Let's say that happened. And then after picking up, selling my house, moving to California, I get to California, I show up at the job, and they say, well, we changed our minds, we're not going to hire you. Well, I relied on what you said and what you promised me and the promise of money, promise of job, etc., to my detriment, and I can then sue you under detrimental reliance to basically say I need to recover the fact that I spent this money to do these things, and now you're screwing me over. So that's why I would have a case to bring. Same thing here. I'm sure these entities, these agencies who rely on these funds made decisions based on the fact that they were anticipating these funds to come in. And while government contracts are never, guaranteed, I've worked for 2 places that was under a government contract, and in each position I lost my position because a lack of government funding had come in. That being said, these people, if you've already made the expenditures and made these decisions to spend the money based off of what the government was telling you that they were going to give you, and the government says, nope, we're not going to give it to you anymore, that is a clear example of detrimental reliance, at least under the principles of detrimental reliance, that, these people should be able to recover those funds because they spent time, money, and effort to be able to, do these things that would be funded by the funds that were promised. A likelihood of success. The government has shown a likelihood of success on the merits of its argument that sovereign immunity deprives the Supreme Court jurisdiction to enter its enforcement order. Why? Explain why. Sovereign immunity bars a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury. Edelman versus Jordan. But what, did Julia Edmonds sue Michael Jordan? What? Just kidding. But this is exactly what the district court ordered here. The restrained defendant shall pay all invoices and letter of credit drawdown requests on all contracts for work completed prior to the entry of the court's TRO on February 13th. Exactly. They already spent the money based off of what the government said that they were going to pay them. So if they've already spent the money, government needs to reimburse them. I understand if you want to stop government funds from going to particular things, but you should do it the right way, i.e., have Congress sign a budget, pass a budget, have Trump sign it, and then you get rid of the funding source, because Congress controls its purse strings, not the executive branch. Sovereign immunity does not justify the president from not spending money that Congress ordered to be spent. If it could, then Biden would have been allowed to no longer build the wall, even though Congress appropriated the money towards the building of the wall. I guess Justice Alito doesn't want to be bothered by such little things like facts. Let's just keep on going. Hoping to escape that conclusion, respondents point to Bowen v. Massachusetts. In that case, we held that the APA's waiver of sovereign immunity covered a district court's judgment reversing a final order. Blah, blah, blah. The judgment did not purport to order any payment be made by the United States. After a court sets aside an agency action, a natural consequence may be the release of funds to the plaintiff down the road. Indeed, we have since clarified that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation, blah, blah, blah. District court however failed to mention, much less reckon with, the other ruling. Excuse me, before plowing ahead with his $2 billion order, nor did it take account any of our previous suggestions that the proper remedy for an agency's recalcitrant failure to pay out may seek specific sums already calculated in, quote, past due. I mean, that could be another remedy, but that doesn't mean that they can't do this here as well. And obviously, 5 of the Supreme Court justices, including your Chief Justice and one of your fellow cronies, Amy Coney Barrett, disagrees with you, Alito, and that's why you're in the dissent on the losing side of this ruling. Finally, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the plaintiff's injuries. Requiring government to spend the money on what the government promised to spend is not that. The district court ordered the government to pay all invoices and letter of credit drawdowns requests on all contracts for pre-TRO work completed. Again, this shouldn't be an issue. If you had invoices to the government for work that was done before the TRO, you need to pay that. I mean, how many times can I slap my head? I just don't understand how Sam Alito graduated law school, passed the bar, even passed the LSATs. I don't understand how this moron is able to justify his continued employment by the federal government. If you wanted to get more government efficiency, you would replace Alito with somebody else who knew what they were doing, who knows their shit. Because Justice Alito clearly doesn't know his shit, as we've seen in this dissent, as we've seen in the various rulings that we've covered done by him as well. Harm to parties and others, the government has shown that it is likely to suffer irreparable harm to the district court's order if it's not stayed. The government has represented that it would probably be unable to recover the money after it is paid. Why would you have to recover monies that were already spent on things that these agencies spent money on based off the government promises? The irreparable harm would be done to these agencies who did work at the behest of the federal government and then can't get paid. But I mean, I guess that's par for the course for the Trump administration, Donald Trump specifically, because that's how Donald Trump made his millions of dollars. He made millions of dollars by not paying people for the work that's done. So shouldn't be a surprise to anybody that Donald Trump is now trying to not pay people who did work for the government, since he made a living of not paying people who did work for him. That doesn't justify this, and to say that forcing a person to pay monies owed causes irreparable harm is just... It would be like, without me declaring bankruptcy, me telling my credit card company, hey, if I pay you what I owe you, it's going to cause me irreparable harm. So therefore, Justice Alito said I shouldn't have to pay you. Again, how dumb is Sam Alito? We usually balance the equities and weigh the relative harms in close cases. But this shouldn't have been a close case. But you have 4 idiots, led by the chief idiot, Sam Alito, who thinks that irreparable harm might be caused by forcing somebody to pay their bills. These are the same people that would tell people with student loans, you should pay your bills, even though student loans have clear provisions that allow for the forgiveness of the debt in many ways. And it empowers the government to forgive the debt in other cases as well. But these are the same people that would say, oh, well, if you raise what people who have student loans, if you raise their payments like Trump is bound to do when they get rid of the SAVE Act, if that happens, are the students be able to say, well, this is causing me irreparable harm, so therefore I should be able to sue and stop them from forcing me to make this payment, because that's the logic Alito uses? No. It's dumb. It's a bad argument. The argument as to why one shouldn't have to pay on student loans is if you hit your thresholds of, hey, I did 10 years working public service, therefore I should have my loans forgiven. Or I've done 20 to 25 years during my normal payments, and therefore, under the terms of my contract, the loans should be forgiven. If there was a contract in place between these entities, these private entities and nonprofits or whatever, and the federal government that enabled the federal government to say, we're not going to pay the debts owed, then sure, show me that. But that doesn't exist. It's just now Donald Trump saying, we don't feel like we should have to pay you because that's who we are. We're pieces of crap, and we don't want to pay our debts. Today, the court makes the most unfortunate misstep that rewards an act of judicial hubris and imposes $2 billion penalty on American taxpayers. It's not a penalty. The taxpayers elected in a Congress and the president to do the will of the people, and the will of the people included these funds being spent on things. The people might not agree on every single thing that was in these, budget items, but we don't get to pick and choose the budget items because we have a representative democracy. Our government works that way, where I'm not going to agree with everything the government spends, but I'm not going to sit here and say I'm harmed because government spent money on something that they promised to spend money on, and they're paying back a debt. At least the Lannisters repaid their debts, or the Lannisters always pay their debts. Apparently, the Trump administration, and Donald Trump in particular, is worse than the Lannisters, and who would have thought? Federal court has many tools to address a party's supposed nonfeasance. Self-aggrandizement of its jurisdiction is not one of them. That's a rather big word for an idiot there, Sam Alito. I would chart a different path that the court does today, so I must respectfully dissent. You might do so respectfully, but you're not doing so intelligently, despite the fact that you're trying to use a couple of $20 words to try and make yourself look smart, because nothing you do can actually make you look smart, Sam Alito. And we've seen that now with this dissent. We've seen it in Dobbs v. Jackson. We've seen it in Burrell versus Hobby Lobby. We've seen it in Salinas v. Texas. We've seen it in Lilly Ledbetter versus Goodyear Tire. How many bad rulings does one have to author before one gets yeeted off the Supreme Court? Let me know in the comments how many more bad rulings or bad dissents that Justice Alito should be able to make before we say this is enough is enough, let's get him off the court. Agree with me, disagree with me, leave your comments down below. Remember to like the video, share it, subscribe to the channel. And of course, unless you're a Nazi or like Sam Alito, have a good day.